Your chairman is Mr. David Milman, who practices with the firm of Castles Brock, very busy in the real estate world in general and condominiums in particular. The second speaker will be Martin Fingerhut, who is with Blake, Castles, and Graydon. Your third speaker this morning will be Mr. Ross Walker with the firm of Messrs. Fraser and Beattie. Your fourth speaker, Nancy L. Carnwath with Macmillan Binch. And finally, Rudy Gardner with Messrs. Faskin and Calvin. Now, you have the papers. Your lecturers will not be, they won't be reading their papers, they'll be speaking to their papers. You are urged to take part in the learning process of the lecture, and then at your leisure or in your working time, read the paper. The papers cannot be fully covered, obviously, within the space of the next 4 hours, but they are there for your further study and interest. You do need to listen carefully to what is being said because all of the highlights will be covered. Now, we're going to have a coffee break after the first two papers. I urge you to get back into the room after the coffee break. Don't prolong it. There will be a panel discussion at the end of the morning, and you're asked to hand in any questions which you may have during the morning. They will be vetted and viewed. The panel itself will have some questions which it has prepared, which are on matters which have to be of interest to everyone. So I wish you a good morning. David Milman. Right on your time.
Now, after having George tell you basically what we're going to be doing, half of my half-hour presentation has already been covered. The only other thing that I have to say is that I was debating whether to plead the fifth when he said that I was busy in the real estate practice. These days, if you're real estate practitioners, you know you're not busy. Not being busy, it came to me that there was very little material available to the profession in dealing with the question of interest. The language that we are dealing with is very imprecise, and words take on very, very strange, beautiful meanings depending on who is using them and where. We have a number of statutes, the Interest Act, the Income Tax Act, the Criminal Code, the Unconscionable Transactions Relief Act, and a lot of other ancillary statutes that deal with the question of interest. Now, the ability to legislate on interest remains with the federal jurisdiction. That has not been changed. The powers still rest with them. What I'm going to do is sort of take a look at what is and what has not been found to be interest by the courts in the interpretation of these statutes. This will give you a groundwork and a basis of understanding the meat and potatoes of the program, which will be by my fellow panelists and speakers. What I have to say is sort of, I feel like the comedian, the warm-up comedian, coming on and trying to fill in for half an hour and give you enough information sort of in a very light manner to get you ready for the headliners. In common usage, interest is defined as money paid for the use of money lent or for the forbearance of a debt according to a fixed ratio. Very simply, money paid for the use of money borrowed. The legal meaning, however, is expanded, and it goes on to say that interest is the return or compensation for the use or retention by one person of a sum of money belonging to or owed to another. Interest accrues from day to day, even if payable only at intervals, and is therefore apportionable in respective time between persons entitled in succession to the principal. Now, interest is something which may be included or deducted from income under the Income Tax Act, depending on which side of the transaction one sits. Now, it's interesting to note that the major statutes, federal statutes, that deal with interest or income do not define the word interest. It's basically left to the courts to interpret how that word is defined from time to time, so that neither the Interest Act nor the Income Tax Act define the word interest. However, the criminal code, the new usury provisions that has created the offense of entering into an agreement to receive or receiving interest at a criminal rate, does define interest. And the criminal code definition of interest means the aggregate of all charges and expenses, whether in the form of a fee, fine, penalty, commission, or other similar charge or expense, or in any other form, paid or payable for the advancing of credit under an agreement or arrangement by or on behalf of the person to whom any such charges and expenses are or are to be paid or payable, but does not include any repayment of credit advanced or any insurance charge, official fee, overdraft charge, required deposit balance, or in the case of a mortgage transaction, any amount required to be paid on account of property taxes. You can see this definition is extremely broad, and if applied literally, would include almost every commercial loan transaction and every type of collateral advantage or participation featured. The Income Tax Act, in dealing with the word interest, basically sets out that there shall be included in computing, and all of you I know are very favorites of the Income Tax Department. You are on a very firm and friendly basis. They come visit you every 4 years at least if you're successful. Otherwise, they just leave you alone. There shall be included in computing the income of a taxpayer for a taxation year as income from a business or property, such of the following amounts as are applicable. Any amount received by the taxpayer in the year or receivable by him in the year, depending on the method regularly followed by the taxpayer in computing his profit as on account or in lieu of payment of or in satisfaction of interest. The Income Tax Act, as I said, have not defined interest, but they did define the word amount, which precedes the word interest. An amount was defined as money, right, or things expressed in terms of the amount of money or the value of terms of money of a right or thing. In other words, anything that would be the equivalent of a monetary consideration. So again, on the face of it, would appear that any collateral advantage that one would receive could be classified as interest. As we will see in discussing the provisions of the interpretation of the cases dealing with the Income Tax Act, the courts have distinguished between what is interest, what is dividends, what is interest, what is capital. Because a dividend, strangely enough, is defined as the interest on a loan or as the profit of a joint stock company. So a dividend is in fact interest because it is compensation for the return of money. But the courts, in order to distinguish and find some difference between the word interest and the word dividend, because a dividend was interest, said that dividends where interest that are chargeable exclusively on profits. So the distinction between interest and dividends as far as the Income Tax Act is concerned is if your return is strictly related to the profits of the company, then it is a dividend payable as opposed to interest. That raises, if you're using it or attempting to use this distinction in a mortgage transaction, to some problems when we, as you will see when we talk about participation and joint venturing. The dividend is the return or consideration for the use or retention by a company of a sum of money belonging to the shareholder and is only payable in the event there is a profit. Once having established that the return is not a dividend and that it is interest, you still have to distinguish between whether it is a capital return or capital appreciation or interest. And again, the reason because of that difference, you will see there have been attempts to capitalize the return by the form of indexing or participation so that the dollar that you lend today hopefully will be the same dollar buying power that you will get back 5, 10, 15, or 20 years from now. As payments under a variable rate mortgage may be insufficient to pay all of the interest that is accrued under the principal because of the variable rate with a fixed payment, deferred interest will be compounded and treated as capitalized. The question will arise is how the Minister of Revenue will treat this capitalized interest, and that is, will the companies have to pay income tax on monies they have not received but have in fact accrued and deferred over the years? I don't know whether they have taken this into consideration, but it is a problem that is going to face them. The tests have been developed by the courts in determining whether a collateral advantage would be treated as interest or some other form of payment, and these basic provisions have been set out in the material. It will be easy for you to follow. I don't feel that I need to read them because I don't think they're pertinent in having to be able to follow what is going to be said. But we can summarize the attitude of the courts when dealing with the question of interest by saying that you really can't generalize. The courts have always basically put in that each case will be determined mainly upon its own facts, so a judgment in one may not be authoritative or binding in another. And this is probably the reason why the legislature has seen fit not to specify or interpret the word interest, because it gives the courts the flexibility and, I guess, the Department of National Revenue the ability to say, well, we deem this to be interest, and hopefully the courts are going to go along with them. There are two interesting cases, both dealt with the Supreme Court within a 4-year span. Both dealt with lawyers. Both were purchasing mortgages at discounts. In one, the court found that buying mortgages at a discount was not the usual investment for return, and therefore the profits realized from the transactions were held by the court to constitute taxable income. I guess a few years later, the courts and the Times indicated that it became a usual practice, so the Supreme Court, a few years later, again, the same case, a lawyer purchasing mortgages at a discount, they felt that it was consistent with making personal investments, and the discount received when a mortgage was paid in full at maturity was held to be a capital gain and not interest income. So you can see that the courts will, depending on the circumstances, find on exactly the same facts two different conclusions. Hopefully, when you are not dealing with the Income Tax Act, which is a very personal act, the others are more generalized, that they will be a little more specific. And in looking at how they deal with the question, under the Unconscionable Transaction Relief Act, interest is part of the cost of the loan. And this is an Ontario statute, and because it's an Ontario statute, they could not define the word interest because they don't have jurisdiction to deal with it. But they have stated that the cost of the loan under the Unconscionable Transaction Relief Act refers to interest as the whole cost to the debtor of money lent and includes interest, discount, subscription, premiums, dues, bonuses, commission, brokerage fees, charges, but not actual, lawful, and necessary disbursements made to a land registrar, a clerk of a county or district court, a sheriff, or a treasurer of a municipality. Legal fees, therefore, would be included in the cost of the loan. So if your legal fees are excessive, it may be unconscionable. Having regard to interest, the Act was attacked as being ultra vires, and the leading case was the Ontario Attorney General of Ontario and Barfried. This was a case dealing with the unconscionability of the Unconscionable Transactions Relief Act, and it contained the most comprehensive definition of interest, and this was given by the Supreme Court of Canada, and basically was the same definition that I gave you at the beginning. Interest, in general terms, is the return or consideration or compensation for the use or retention by one person of a sum of money belonging to, in a colloquial sense, or owed to another. And interest accrues, and this is the most important factor because the whole basis of what interest is followed on the following words. Interest accrues de diem in diem, even if payable only at intervals, and is therefore apportionable in point of time between persons entitled in succession to the principal. The day-to-day accrual of interest seems to be the essential character. It would appear that we now know what interest is. Let us now look at some of the other forms of compensation for the use of money and what the courts have considered not to be interest. As lenders can extract any collateral advantage from a borrower as consideration for granting a loan, this was laid to rest way back in the 30s. The leading case was the London Loan and Savings and Meagher, and in 1930 the Supreme Court of Canada said that there is now no rule in equity which precludes a mortgagee, whether the mortgage be made upon the occasion of a loan or otherwise, from stipulating for any collateral advantage, provided such collateral advantage is not either unfair and unconscionable, in the nature of a penalty, clogging the equity of redemption, or inconsistent with or repugnant to the contractual and equitable right to redeem. The viewpoint of a person that has money to lend, he is not concerned with what you call interest, how you do it. He just wants to know the bottom line. What is his return going to be for the use of his money? He couldn't care less whether it's by way of a bonus, collateral advantage, participation fee, processing fee. So what may appear to be equitable today in a long-term participation or collateral advantage where you have an option to purchase, etc., for fixed fees, may turn out to be unconscionable or a breach of the usury provisions of the criminal code at some future date. For these reasons, when we draft or be involved in the drafting of commitments, it is important to be concerned with how the return is being allocated between the borrower and the lender. Because if we go too far one way or too far the other, we can run afoul of one of the statutes or one of the laws that are affecting the return on compensation. The Interest Act probably is the most important one to consider when looking at compensation packages for the use of money and how we structure them. You'll see from Rudy Gardner's material that the penalties that arise because of the non-compliance with the provisions of the Act can be quite severe. Going back to the London Loan and Meagher case, there was the clearest statement dealing with bonuses in that case, that a bonus for the placing of a mortgage is a collateral advantage which a mortgagee can validly provide for in his agreement to lend money. Even though a bonus secured by way of a collateral agreement may not infringe the Interest Act, it may nevertheless be struck down as being unfair and unconscionable. There also is the option rights or rights of first refusal, which may form clogs of equity of redemption. And an interesting case dealt with, it was not a mortgage of land, but it dealt with certain wool brokers lending money to a company in the business of meat processing. And the loan was secured by way of a floating charge on the undertaking of the company. The loan agreement included a term that for a period of 5 years, the borrower would sell sheepskins only to the lenders at a stipulated price. The loan was paid off in accordance with the agreement, and the lenders continued to claim the right to exercise their option of preemption, notwithstanding the fact of repayment. And the court held that the stipulation for the option formed no part of the mortgage transaction, but was a collateral contract entered into as a condition of the company obtaining the loan, and found that it was not a clog on the equity of redemption or repugnant to the right to redeem. So lenders are entitled to obtain injunctions restraining companies from selling sheepskins to other persons other than the lenders in breach of the agreement. Where the court finds that the so-called collateral advantage is in fact a term of the mortgage itself, no matter how fair or reasonable it may be in terms of the agreement between the parties, it probably will be unenforceable if it prohibits the borrower upon repayment from discharging all his obligations thereunder, as it will be held to be a clog in the equity of redemption and void. The basic fact we must consider is that a collateral advantage must not completely prevent the borrower from redeeming the mortgage asset. Wherever possible, it should form part of a collateral document and not be the subject of the mortgage document. Now, you can collaterally secure the collateral advantage in the mortgage document, but there should still be a separate document executed by all of the parties. One of the major reasons for that particular statement is found in the operation or combined operations of Section 110 of the Bankruptcy Act and Section, I believe it's 4 of the Partnership Act. And the operation of these two sections, if the agreement between the lender and borrower, where there is a participation feature, is not executed by both of the parties, the protection that's given in the Bankruptcy Act and in the Partnership Act doesn't exist. And very rarely does a mortgagee execute a mortgage document. So there is, in the event of a bankruptcy, a definite need for a mortgagee to have his collateral advantage properly secured by a separate document. An issue that we have to determine is whether the participation provisions in a mortgage could be construed as interest, because participation is a form of compensation. And the court found that sums generated under a participation clause in a mortgage, under which the mortgagor agreed to make further payments by way of a percentage of gross annual rentals after a base figure was reached were not interest. Anderson went on to say in this particular case, it's the Blagey Apartments, that I see no distinction between a payment by way of a bonus, clearly disclosed as such in the mortgage, and a payment calculated as a percentage of annual income, likewise clearly disclosed as such in the mortgage. If the former was not interest, neither is the latter. Well, with due respect to Mr. Justice Anderson, he has forgotten that under the definition of interest, that it accrues per diem, in diem per diem, a bonus does not accrue on a daily basis. However, participation in profits, in gross revenues, do or does or may accrue on a day-to-day basis and therefore fall right on all fours with the present legal definition of interest. So the question of the participation provisions in a mortgage document or agreement may potentially run afoul of the provisions of Section 6 of the Interest Act, and for that reason, there is, again, the importance of having a separate agreement or participation agreement in addition to the mortgage document. A clause in a mortgage requiring a repayment of a principal interest in an index amount based on the Consumer Price Index was found not to offend the Interest Act, was not a clause in the equity of redemption. As I mentioned before, when we talked about the return of principal or the capitalization of principal, there was a recent case, North American Life Assurance. This was in 1981. The mortgage contained a participation clause under which the plaintiff was entitled to an annual accounting and payment of a portion of the gross income from the mortgage premises. The mortgagee was not bound to accept payment of the principal before the time provided for in the mortgage. The defendant defaulted under the participation clause because he failed to provide financial statements and pay a portion of the gross income owing to the plaintiff. In an action for the accounting and payment of the amount owing under the participation clause, the defendant argued that the participation clause was illegal and void because it prevented him from exercising his right to redeem. The court found that the participation clause merely stipulated a collateral advantage and did not restrict the clog or the equity of redemption. The question did not arise as to whether there was a breach of the Section 6 of the Interest Act, and therefore the penalty provisions would be applicable. The court in this particular case stated that the test that had to be applied as to whether a participation clause had the effect of reducing or cutting down the right to redeem was, once a mortgage is a mortgage, again, the necessity of having a collateral advantage done by a separate agreement, because if it's not in the mortgage, then there is no provision for reducing the right to redeem. A mortgage cannot stipulate for a collateral advantage that would make his remuneration exceed a proper rate of interest, that is, being unfair or oppressive. Again, the need for a separate collateral agreement, and it cannot clog the equity of redemption. The other thing to remember is that a participation provision is in fact an assignment of part of the mortgagor's receivables, and therefore appropriate registrations should also take place under PPSA or the CSRA if applicable. I touched on the indexing of return And basically, that is dealt with quite fully in my material, and I'm going to skip over it. The unconscionability and as dealt with by the Criminal Code and the Unconscionable Transactions Relief Act will be dealt with later by my heavies. In going on and rambling for the past half hour, it reminds me of a story of a lawyer who was a phenomenal fisherman. He was the only one that was able to get fish out of this little hole, and no one could ever figure out how he was so successful. His best friend was one of the fisheries and games wardens with the Department of Fisheries. And after a drinking bout one night, he finally convinced the lawyer that you should take me out. I'd love to be able to catch. I've never been able to catch fish at this particular hole. So the two went out, agreed to meet at the certain spot. The lawyer showed up, a small little metal briefcase, no fishing equipment, huge net. Games warden looked at him, just couldn't figure it out, just kept quiet. They drove off, got in, found this little spot on the river, got into a boat, and it was a strange boat. It was all steel-plated, and it had a cover with a small little hatch on top. And they drove off, spent about half an hour winding their way up this river, and they finally stopped. The lawyer opened up his little briefcase, took out a stick of dynamite, lit it, opened the hatch, threw it out, closed the hatch, and then the boat shuddered and reverberated. When all was still and the water splashing stopped, threw back the top, took his net, and then just skimmed all of the fish that had been stunned and had floated up to the surface of the river. The games warden was aghast. He said, "How can you, a man of the law, go and do such a dastardly deed?" And the games warden kept going on, and he was lecturing, and after at least half an hour, the lawyer finally reached into his little metal briefcase, took out another stick of dynamite, lit it, handed it over to the game warden, said, "Are you going to fish or are you going to still talk?" With that, I'm going to let you go fishing with the heavies and introduce the next speaker. Thank you. Marty Fingerhut, partner of Blake Castles.
Thank you, David. I will be discussing the legal aspects of variable rate mortgages. And I think basically our session this morning will divide variable rate mortgages into two segments. I'll look at the statutory or common law basis for indicating that that is a possible route to follow. And Ross Walker will go through clause by clause a number of variable rate mortgages that are now in fact in the marketplace, and will indicate the manner in which they have stayed within the legal framework that we'll discuss in the next half hour or so. I think the first point to make is that there does not appear to be any common law or equitable principle that would in itself militate against having a variable rate. This is enforced by Section 2 of the Interest Act, which is set out at the bottom of page 1 of my paper, which says that unless another federal statute otherwise provides, parties may agree to pay and collect any rate of interest that they agree upon by contract. The question, I think, therefore, falls down to, is there any federal statute which would make invalid or restrict the enforceability of a variable rate mortgage? Some persons have pointed to Section 3 of the Interest Act as being such a section. That's on page 3 of my paper. And that says that where interest is payable, either pursuant to a contract or pursuant to a statute, but no rate is fixed by law or by the agreement itself, then the rate that can be collected is restricted to 5%. Question comes down to, what does the word fixed mean? There have been a number of early cases, which I summarize in the paper, that don't talk to Section 3, but do talk to the meaning of fixed in various contexts. And they were helpful in indicating that fixed does not mean specified rather than determinable. However, the matter has now been put beyond doubt by a recent case in the Supreme Court of Canada, the British Pacific Properties case. In that case, there had been an expropriation award under which interest was granted at a rate equal to the prevailing rates for 90-day finance company paper, a very variable rate. It was argued up to the Supreme Court of Canada that that provision in the award violated Section 3 as requiring the rate to be fixed by law, in that case, since there was not an agreement or a contract being looked at. The Supreme Court of Canada disagreed, and Mr. Justice Laskin, who gave the decision, basically said that as long as there is a mechanism that is fixed in the contract or in the law, the statute under discussion, under which the interest can be determined, that is full satisfaction, full compliance with Section 3. To put icing on the cake, our recent unreported case, Tron-Dominion Bank and Connolly, referred to on page 5, has now held that in the specific situation, and they follow the Supreme Court of Canada case, but in the specific situation, it is fine to have a rate which varies with the prime rate of a chartered bank. If we take it as settled that you can have a contract to pay a variable rate of interest, the next question is, are any additional problems or any problems caused by the fact that that variable rate is contained in a mortgage? Again, I'm not aware of any common law or equitable principles or any principles of land law or contract that would cause a problem. And therefore, I think we're again put back into the statutory exception. Is there anything in the statutes which cause a problem in a mortgage of land providing for a variable rate of interest? At this point, a number of persons have been concerned over the years with Sections 6, 7, and 9 of the Interest Act, which at first blush seem to say that you can't have a rate which varies because you've got to specify the actual rate in the mortgage itself. Those sections are set out on page 8. Basically, Section 6 says that where principal or interest are made payable on one of the three plans that are very briefly described in Section 6, then the mortgage must set out a statement which contains both the amount of principal, which is easy, as well as the rate of interest, which is chargeable, and that rate of interest must be expressed as being the half yearly. How it's expressed, it must be expressed as being calculated half yearly, not in advance. If that statement is not set out in a mortgage which has one of those three plans, then no interest whatsoever can be recovered. The three plans are a plan under which interest and principal are blended, where the payment is a blended payment of both principal and interest. The second is where it's a payment made on the sinking fund plan. And thirdly, any plan under which involves an allowance of interest on stipulated repayments. assuming we have one of the plans that Section 6 requires, and we have the statement which Section 6 requires, Section 7 goes on to say that no other provision of the mortgage can require the mortgagor to pay any interest or pay any amount which would effectively increase the rate that was disclosed to him in that statement. Section 9 then provides that if the mortgagor in fact pays interest in a situation where, because of the operation of 6 or 7, he wasn't required to pay it, then he can recover that amount back from the mortgagee by suit, by litigation, or by just offsetting it from any other amounts that he owes to the mortgagee under the mortgage. Now, as to Section 6, although there are 3 plans there, 2 of them, sinking fund plans and plans which involve an allowance of interest on stipulated repayments, one, A, can't find them in practice, B, the references in the cases are very meager. The cases mostly say this particular formulation is not, whatever it means, the particular formulation before the court does not come within those 2 other plans. And therefore, we're going to get very little help from the authorities as to what those 2 plans are. Fortunately for us, in practice, what we will see is something that would be argued to be a blended payment mortgage, and I'll confine my remarks to that type of plan. The concern as to Section 6 is based on 2 premises when we have a variable rate mortgage providing for a rate which can vary from time to time. And those 2 premises are these. First, that a mortgage which provides for payments, which payments are made up of both interest and principal components, must necessarily be a blended payment mortgage. And secondly, that mortgage cannot comply with the statement requirement of Section 6 if it sets out a variable rate. One of the difficulties in interpreting Section 6 is that a number of the cases fail to give a critical analysis as to what Section 6 really requires. However, the leading authorities approve a 2-step analysis, which is set out at the bottom of page 9 of my paper. And the first step, and it seems like an obvious one, is to determine whether or not the amounts in question are in fact payable on one of the 3 plans set out in Section 6. And for our purposes, are the amounts payable in a blended payment context? The second question is, if it is payable on one of those 3 plans, is the statement required by Section 6 set out in the mortgage? As to what blended means, it will be surprising to many, as it was to me, that the courts have consistently held that the mere fact that a payment includes both a principal and an interest element does not, by virtue of that fact, result in the payment being blended for the purpose of Section 6. One of the earlier cases on the subject was the Cummings and Silverwood case, referred to on page 10. And in that case, it provided for a payment of $12,000 on maturity, made up of a $10,000 principal payment and $2,000 worth of interest. The court held that that mortgage did not provide for a blended payment. The court said that mere addition is not blending. It refers to Murray's English Dictionary, which said that the most frequent use of blend is in the sense to mix components intimately or harmoniously so that their individuality is obscured in the product. And it went on to talk about what mischief was aimed at by the section. And it said that the mischief intended to be remedied by the statute was one resulting from the fact that blended payments obscured the interest included therein. A subsequent Ontario case, Bouchard and Budge, said something very similar in following that case. I consider, therefore, that the word blended means mixed or confused in such a way that the individual components cannot be discovered. So we're getting down to a scenario which suggests that if you take that payment which is made up of interest and principal, and you can, and the mortgagor can divide that payment into its interest and principal components, we will not have a blended payment. That analysis was confirmed by the Supreme Court of Canada in the classic case on the subject, which is Kilgoran Hotels in Samak. Very short case, which is fortunate for analysis. And basically, you had a mortgage which provided, in that case, for quarterly payments to be made every quarter. And the interest rate was also calculated quarterly. So it was important for the purpose of Section 6 to determine whether that payment was blended, because there was no statement as to the interest rate as calculated half-yearly. The interest rate was calculated quarterly. Well, the court held that those payments were not blended because it was easy for the mortgagor to separate the payment into its principal and interest components. And this is the basis for all the subsequent cases. The cases following that case was in 1968. All the cases to date have followed that analysis, looking at the purpose of the section to protect the mortgagor from being deceived by the use of a blended payment into knowing how much his interest payment would be. At trial, the Kilgoran case held as follows: to fall within the section, the mortgage must set out a plan of repayment in such a manner, this is the bottom of page 13, that having regard to the whole plan, the components of principal and interest and specified payments are so mixed that they cannot be readily discerned. The subsequent cases, and I think the majority of them are in Ontario, have set up a number of principles by way of distinguishing the Kilgoran case, telling the draftsman how he must draft his mortgage so as to come within the principle of Kilgoran, so as how to make your mortgage enable the mortgagor to easily divide up his payment into its principal and interest components. The first principle, as indicated by the McGoran case, is that the mortgage must provide expressly that the payment is to be applied first to interest and secondly to principal. If the mortgage didn't provide that, the mortgagor wouldn't know how much of his payment would go to interest, and therefore he wouldn't know for either the first or subsequent payments how much of that payment was in fact interest. If he's told that it goes first to interest, he makes his calculation, how much interest is accrued. He applies that interest accrued to the payment, the balance goes to principal, and he has a new starting date for the next calculation. The case went so far, however, as to say that even if, as a matter of law, that provision would be implied in the mortgage, that wasn't sufficient. The mortgage itself had to make it easy for the mortgagor. We wouldn't rely on implied legal principles, and that clause has to be right in the mortgage. A number of standard forms, such as Dine and Dern, will have that. Other forms do not have that particular provision, although all the, as Ross will indicate, all the variable rate mortgages now in the marketplace that we've looked at do have that particular provision. The second principle relates to how interest is to be calculated. You'll recall that in the Kilgoran case, the mortgage interest was calculated quarter yearly, and it was also payable quarterly. It's been held in the Tilson case that it's necessary for the payment and the calculation bases to be the same. If interest is payable monthly, it must be calculated monthly. If it's payable quarterly, it must be payable quarterly. If it's calculated half-yearly, it should be payable half-yearly. The reason for this, and Nancy will go into this a little later, is that if it's payable monthly, for example, more frequently than it's calculated, say half-yearly or quarterly, then it's an awfully difficult mathematical exercise to determine how much interest actually accrues to the date of payment. This theme reinvestment of principal theory and other theories make it a computer exercise, and therefore, as indicated in the Tilson case, that is not providing the mortgagor with an easy way to determine how much interest is in his payment. If in fact it's calculated and payable on the same basis, he just sits down and does his calculation using the numbers interest rate and principal that he has. The other two principles, two others I'll refer to, are in one respect refinements of all I've said. The third principle is indicated by the Hudlin case. In that case, the mortgage was relatively poorly drafted. It had ambiguous provisions. It had inconsistent provisions. It was obviously an amalgam of some different forms put together for a particular purpose. And the court had trouble reading it through in an easy way. Now, the court did find it had a legal meaning. They didn't say it was void for uncertainty, but they found that it was because it was inconsistent, because it would be difficult for an ordinary mortgagor to understand it, they held that it was blended, contravening the principle that the division of interest in principal should be made easy for the mortgagor. And finally, the cases suggest, they don't specifically hold, that the mortgage calculation should be not complex. It can be clear, but in addition to being clear, it should be relatively easy to do. For example, the Kilgore case held that it was all right, it wasn't blended, because the principal interests were clearly stated, and the quarterly payments could very easily be distinguished as to the principal and interest portions. The arithmetical calculation involved in each payment was quite simple. Since variable rate mortgages are still somewhat of a novelty, the easier it is for the mortgagor to separate the interest and principal components of his payment, the more likely it will be for the court to conclude that the mortgage is not blended and therefore does not come within the requirements of Section 6. If we conclude that we can draft a mortgage that complies with Section 6 in that it is not blended and therefore it doesn't have to comply with Section 6, we could stop right there. However, being lawyers and being somewhat conservative, it is perhaps desirable to cover our bets. And we should consider what the requirements of Section 6 are in the event that a court holds, for whatever reason, that the provisions of the mortgage payment clause set up a blended payment mortgage. Section 6, as indicated before, provides that no interest at all will be payable if a statement is not contained in the mortgage where it's blended that sets out the rate of interest calculated half yearly. It would seem prudent, therefore, at least until a satisfactory body of law is developed, for the mortgage to set out the yearly or half-yearly equivalence of the rate of interest initially payable under the mortgage. That's the statement required by Section 6. In addition, it would seem useful to set out in a schedule the yearly or half-yearly equivalence of the various interest rates that might apply to the mortgage over its term, indicating a desire to disclose as much information as possible to the mortgagor and give him all the information that one can possibly do as to what the half-yearly rate of interest will be given various mortgage rates, various prime rates, if prime is the index that one is following in the mortgage. Thus, if the mortgage provides for interest at the prime rate of a chartered bank calculated monthly, the mortgage would set out the rate of interest which, when calculated half-yearly or yearly, was equivalent to 20% calculated monthly, and would state that this rate was the rate initially payable under the mortgage. And a schedule to the mortgage would set out a number of possible prime rates, such as rates from 20, well, let's go back, rates from maybe 10 to 25% in quarter-percent increments, and the appropriate equivalent rates calculated, again, either yearly or half-yearly. In this way, the mortgage can be said to contain the statement required by Section 6, even though, as a matter of law, the court should hold that statement is not necessary. We should look at Section 7 briefly, although I've mentioned it before. The purpose of that section, as I've said, is to protect the mortgagor from the provisions of a mortgage which would require him to pay interest at a rate that's greater than that set out in the statement. And therefore, if a variable rate of interest is held to provide for a blended payment, and thus require the statement described in Section 6, and if a statement of a yearly or half-yearly equivalent rate is inserted in the mortgage, as I have suggested, the mortgagee might be restricted to interest at that equivalent rate because of the effect of Section 7. However, as I've noted above, I don't believe that the mortgage will be held to be blended. The cases are very much in favor of that proposition, therefore making the statement unnecessary, and as a result, making applicable the provisions of Section 7. The result would be that the provisions of the mortgage would be carried out in accordance with the intention of the parties. Thank you.
Instead of breaking for coffee now, we're going to divert from the agenda and have Ross come in and discuss the provisions contained in the VRM mortgages so that it's right after Marty's discussion. And after that, we'll take the coffee break. Without further ado, Ross.
Load up here first. I've been asked to attempt to guide you through specific examples of variable rate mortgages, and for that purpose we've selected three different variable rate mortgages: the Kinross mortgage form, which is now CIBC Mortgage Corporation, the Royal Banks form, and the Canada Trustco mortgage form. And even though they're all variable rate mortgages, they're very different in several ways. The Kinross mortgage form even provides that even though interest will vary with the base rate, the monthly installment of principal and interest remains fixed throughout the term of the mortgage within certain limits. The Royal Bank form is strictly a demand mortgage, which does not provide for monthly installments of principal and interest. And the Canada Trustco mortgage is in between. It's payable on demand, but until demand, it provides for, it permits the mortgagor to pay monthly installments of principal and interest, which are fixed. And I'll limit my remarks to the interest provisions of these mortgages, and I think probably the best way for you to follow my lecture is to turn to page 78 of your materials, where I've had photocopied the interest provisions of these three mortgages, and I've attempted to identify certain provisions by a letter designation to which I'll refer, but which also refers to the various sections of the paper when you have a chance to go through the paper. Marty has explained to you what the law is with respect to the variable rate mortgages. What I'm going to try and do is tie that law into the specific provisions and explain why the draftsman drafted the mortgage as he did. I think probably the first important part is the base rate. There has to be a base rate on which will determine the actual rate. I don't think it really matters, with a couple of exceptions, exactly what the name given to that base rate is, but it's certainly important that each mortgagee be able to prove what that base rate was each day throughout the term of the mortgage. Otherwise, he's going to be confronted with an evidentiary problem. The Kinross mortgage chooses as its base rate, and it's designated as letter A on page 78, the mortgage prime rate of Canadian Imperial Bank of Commerce as declared by that bank from time to time. It's pretty arbitrary, pretty much in the discretion of the CIBC. It's as declared by the CIBC. Canada Trustco also talks about its base rate as the Canada Trustco Mortgage Company's prime homeowner loan rate from time to time. When you get to the Royal Bank form, the Royal Bank chooses the words residential loan base rate of the mortgagee, but then goes on to define it with a very complete definition. It talks about the annual percentage rate of interest charged from time to time by the mortgagee in accordance with prevailing market conditions on demand homeowner loans in Canada secured by a demand first-ranking collateral residential mortgage made to and accepted by the mortgagee's best risk customers in its variable interest rate residential loan program. Very, very complete. I think perhaps one disadvantage of such a definition is that the mortgagee is certainly bound by the criteria that the mortgagee establishes, and perhaps if it runs afoul of that, could run into difficulties. With the Kinross form, it's as the bank declares, so you can be a little more flexible in terms of how you set your base rate, but on the other hand, you don't have the same kind of certainty. One other potential danger with respect to the base rate, and I don't think there are any cases on this, but it's always concerned me when I see a prime rate of interest or a rate at which money is made available to the mortgagees or the lender's best risk or most creditworthy customers, if that lender then loans to some of its borrowers at prime less a half or prime less a quarter.